Namaste. So now let's prepare an answer on the writ jurisdiction of the Supreme Court. So anytime they ask you to comment on the writs, anytime they ask you a question on habeas corpus specifically, anytime that they ask you to elaborate on the writs, the writ jurisdiction, etc. This is a standard set answer. ये सारी details जानी ही है, चाहे कौन सा भी प्रश्न आए, ठीक है जी. So right और basically आप अपना आंसर यहाँ से start करेंगे. That Supreme Court is the highest court in India. It has been empowered to issue writs in the nature of, straight get into this, habeas corpus mandamus prohibition quo warranto certiorari. This is I believe standard. आपने prelims के लिए जब prepare करा भी होगा तो standard stuff है. For enforcement of rights under part 3. Now do mention this sentence. So part 3 के अंदर क्या contain है constitution में? That's fundamental rights, right? So how do you enforce your rights via the Supreme Court? Via writs. All right. Now High Court की jurisdiction is slightly separate. It runs parallel, but है थोड़ी सी separate. So the right to move the Supreme Court itself is a fundamental right because Article 32 is under Part 3. Let the examiner know. Do not miss out on this line. So please do examiner. मतलब जब आप ये answer लिख रहे हैं, please do let the examiner know. क्योंकि without these lines, then we start losing out on very easy marks that we could have fetched. All right. So the High Court too has writ jurisdiction. The Supreme Court's territorial jurisdiction is wider. So if you read Article 32 and if you read Article 226 in tandem, you will find कि Supreme Court में आप writ कहीं पे भी आपका fundamental right in the entire the territory of India has been violated, you can file a writ. But in High Court, only for example, अब Delhi High Court में कोई भी writ, let us say Kerala में कोई fundamental right violate हुआ तो यहाँ नहीं आपकी writ लगेगी. That will specifically go to the Kerala High Court. But अगर आपके पास एक alternative remedy available that you can directly approach the Supreme Court because Supreme Court की territorial jurisdiction is wider, but the High Court's writ jurisdiction is wider. How? Because of Article 226, because it says for any other purpose. वहाँ पे any other purpose लिखा हुआ है. So for example, violations in the nature of in which your legal right is being violated, legal right, fundamental right तो purely आप Supreme Court के पास जाएंगे. But any right that is legal in nature and is being violated तो आप High Court के पास जाएंगे और fundamental right के लिए भी जा सकते हैं. Therefore the High Court's writ jurisdiction is wider. Hopefully it is clear. High Court में आप fundamental right plus legal right violations के लिए जा सकते हैं. So it is little wider. Supreme Court में आप सिर्फ और सिर्फ for violation of fundamental rights. Now secondly, Supreme Court territorial jurisdiction is wider. High Court कम है. High Court के ऊपर जो area based, it is bound by the area. All right. So in Charanjit Lal Chaudhary versus Union of India, the court cannot, it was decided that the court cannot throw a petition away simply on the ground that proper writ has not been prayed for if fundamental right is violated. Try to mention this in your answer. अगर आप नहीं भी mention करते तो ADM जबलपुर तो mention करना ही है, अभी हम उस पे आ रहे हैं. तो ये आप pause करके आप लिख लेते हैं. So Supreme Court's writ jurisdiction is concurrent with the High Court. अब High Court में Article 226 सदा ही सदा आपने mention करके आना है. ये मैं नहीं करा. जब मैं ये मेंशन करूँगी आप आर्टिकल 226 मेंशन करें तो आप ये वर्ड टू वर्ड नहीं लिख सकते. इट इज ह्यूमनली इम्पॉसिबल टू रिमेंबर. आर्टिकल 226 पावर ऑफ हाई कोर्ट्स टू इशू सर्टेनिटीज. दैट्स इट. अच्छा ये भी वर्ड टू वर्ड ना याद हो कोई फर्क नहीं पड़ता, बट जस्ट मेंशन आर्टिकल 226 सो दैट द एग्जामिनर नोस. नाउ notwithstanding anything in Article 32, that's a non-obstantive clause. Every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction. ठीक है जी. And basically or any of the for enforcement of any other rights conferred by Part 3 and for any other purpose. So rights which are of legal nature not covered by Part 3 कहाँ जाएंगे 226 and go to the appropriate approachable High Court. ठीक है जी. Now therefore HC's power with the writ jurisdiction is wider with respect to enforcement of non-fundamental rights. ठीक है जी. And this is ये एक्सक्लूसिव है हाई कोर्ट के पास. आप लीगल राइट आपका वायलेट हो रहा है, एनी स्टैट्यूटरी राइट बीइंग वायलेटेड, हाई कोर्ट जाएंगे, सुप्रीम कोर्ट नहीं जाएंगे. सुप्रीम कोर्ट फंडामेंटल राइट की वायलेशन में जाएंगे. ठीक है जी. अच्छा, नाउ यू विल स्टार्ट इलैबोरेटिंग ऑन द रिट्स इन योर आंसर. सो हेबियस कॉर्पस इज वेल इट मींस हैव द बॉडी, या कई लोग कहते हैं ब्रिंग द बॉडी, कई एमसीक्यूज में आता है वो ब्रिंग द बॉडी मार्क करा दो. हैव द बॉडी, ब्रिंग द बॉडी, किधर लेकर आओ इसको. So this is one of the most ancient writs known to English common law. That is how you frame out your answer. Under the writ, court orders the person who has arrested an individual to produce that individual before the court so that the court can know the reasons as to why he has been arrested. This is one-to-one language I want you to write in your answer. So usually when I'm explaining stuff on YouTube, I never dictate out what is written on the screen. But herein, since we are primarily our online course is focused on answer writing, I want you to write it down word to word. तो लेक्चर पॉज प्ले करके आप कृपया करके इसको आप लिखिए वर्ड टू वर्ड, क्योंकि अगर आप इसका 70% भी रेप्लिकेट कराए, ऑप्शनल में कैसे नहीं नंबर आएंगे मैं भी देखूंगा. So by this writ, the court tests the validity of the act which robs a person of his personal liberty. See, this is absolutely stellar, beautiful language, and this is not my language. I have picked it out from books. So कृपया करके let us try to stick to this mode of language only. All right. Now, principle of res judicata does not apply because the decision or order made under this writ is not a judgment. तो अब वैसे भी this writ of habeas corpus is about personal liberty as से. Now आपकी personal liberty etc. तो constitution तो बिल्कुल ही आपके पीछे, मतलब this is they are mad obsessed with personal liberty. अब why is it exempt from the principle of res judicata? Now what is res judicata? कि ये पहले हो चुका है जी, इस पे decision आ चुका है, इस पे दोबारा बहस नहीं होगी. Habeas corpus is exempt from res judicata because it's a matter of your personal liberty. अब कल को कोई और fact आए तो आप दोबारा क्या कोर्ट जा सकते हैं. लेट अस से once a high court dismisses your habeas corpus petition, can you again go to the Supreme Court, not an appeal, as a fresh case? Yes. Let us say the Supreme Court dismisses it. Can you again go after 3-4 months, let us say some new fact has emerged? Yes. Not in any other writ, not in any other matter, because it will be barred by res judicata. तो कृपया करके एग्जामिनर को प्लीज ये बताकर आना ही आना है. And I'll attach another lecture from YouTube right after this one that I had done on why habeas corpus is explicitly barred from, or rather is exempt from res judicata. तो उससे भी ये फंडा और भी क्लियर हो जाएगा. वैसे usually we are focusing on answer writing, so this lecture will suffice, but as a bonus thing we'll just attach it in the course. In the immediate next lecture आपको ये वाला मिल जाएगा. Now in the pre-independence era, this remedy was used / available only for Europeans, not available to Indians. So this answer में से आप actually अपना एक habeas corpus पे भी आंसर काट सकते हैं. अगर सिर्फ explicitly habeas corpus के बारे में बात करें तो प्रभु को ये दिन है, ठीक है जी. But in 1922, in reference R.E. Govind Nair, the Madras High Court or Madras High Court actually observed that such a writ can be given in case of Indians too. Without mentioning this, the note on habeas corpus will not get complete. So please, कृपया करके ये काम आप करेंगे. The Privy Council confirmed this, and now we talk about when is it not available. So basically, अब 1922 के बाद habeas corpus became available to Indians. It originally was not mentioned it. Now when is it not available? So a convicted person undergoing punishment, if a new legally valid order is executed against him on his release, he cannot be released. If the detention is not ultra vires, the powers basically of the authority of which has arrested you, the person cannot be released. Violation of fundamental right is sine qua non. कोई ना कोई पार्ट 3 में आपका fundamental right violate होना ही होना है, तभी आप ये रिट लगा सकते हैं. रिट कहीं कहाँ नहीं लगाएंगे. If you have already been convicted and you are undergoing trial, then obviously you cannot file a habeas corpus. नहीं तो पूरी दुनिया ही सुप्रीम कोर्ट पहुंचेगी, वैसा habeas corpus लगाओ, इधर बुलाओ, इसको वापस बुलाओ, right? Now, if a new legally valid order is executed against him or his release, he cannot be released. For example, let us say habeas corpus से आप आ गए, but then फिर आपका trial चला and then again you were convicted. मतलब again in the sense कि you have now been convicted, तो obviously आपकी habeas corpus अब नहीं चलेगी, right? If the detention is not ultra vires the power, this I believe is self-explanatory. Then we go to Ghulam Server versus Union of India. कृपया करके इसको लिखिए. And Supreme Court held that detained person can file an original application for enforcement of his fundamental right for liberty before the Supreme Court, despite adverse order of High Court. It is not a bar to file a habeas corpus की petition. So refusal to obey the writ of habeas corpus, well, it's contempt of court. Case law लिखना है तो Ghulam Server versus Union of India. Then habeas corpus के ऊपर नोट पूरा ही नहीं हो सकता without mentioning ATM W versus Shivkant Shukla. The habeas corpus case, 5 different judgments came in, but by a 4:1, and this is bad law now because this was pretty much termed as bad law, and then it was overturned in Justice K. Puttaswamy versus it was State of Kerala, I believe, या Union of India, the Aadhaar case basically, ठीक है जी. तो उसके अंदर ADM जबलपुर was held to be completely bad law. तो यहाँ पे क्या हुआ था कि अच्छा डिसेंट किसने दिया था? मिस्टर HR खन्ना, neither roses nor thorns. So 5 different judges, and then basically they gave the decision by the majority that no person has any locus standi to move High Court in a habeas corpus in a High Court petition during an emergency, which led to the 44th Amendment, which led to 20 and 21 कैन नॉट बी सस्पेंडेड इवन ड्यूरिंग इमरजेंसी. तो pretty much this case law was overturned by the 44th Amendment. One aspect was it, and then this was recognized as bad law in Justice K. Puttaswamy judgment, that is formerly known as the Aadhaar case. यहाँ पे HR खन्ना जी ने आपके जो था, जो बहुत पॉपुलर जज थे, CJI शिप वाज आल्सो स्नैच्ड अवे बाय इंदिरा गांधी. यहाँ पे इस साइड पे आपके आधार केस में जो डिसेंट जो दिया था, नॉट ऑन दिस एस्पेक्ट, डिसेंट जनरली ऑन आधार केस बिकॉज इट वाज पास एज अ मनी बिल, वाज बाय जस्टिस चंद्रचूड़. जाबरीमाला के केस के में डिसेंट किसने दिया था? जस्टिस इंदु मल्होत्रा. ठीक है जी, ये आपने काम हो गया. देन यू विल गो टू सर्शियरी. सर्शियरी मीन्स टू सर्टिफाई. नाउ बाय दिस रिट द सुपीरियर कोर्ट्स restrict the lower courts / tribunals from, so usually tribunals आपको किताबों में मिलेगा, they are administrative authorities, right? So from exceeding their powers and functions. Now this is both a preventive and a curative writ. So certiorari and probation run parallel with each other. Certiorari you can say is a much more evolved form of prohibition. ठीक है जी. It is issued after, ये बात आप एग्जामिनर को बता के आएंगे कि आपको अंतर पता है प्रोहिबिशन और सर्शियरी में, that it is issued after to quash a decision after it has been taken. सर्शियरी पहले नहीं लगती. The lower body has to basically pass an order for it to get quashed by certiorari. But prohibition में आप पहले लगा देते कि वो रुको क्या कर रहे हैं, right? So this is, prohibition is issued before proceedings are complete. Once proceedings are complete, what will you apply for? What will you file a writ for? That's certiorari. Crucial difference. Tell the examiner that you know this. बहुत ही कमाल के आंसर निकलेंगे हमारे, right? And cannot be issued against ministerial and purely executive act. Certiorari cannot be. अब ऐसा है ना, मिनिस्टर साहब ने काम करा, आप हर चीज में certiorari लेके पहुंच गए कोर्ट में, वो काम ही कैसे करेगा अपना? If you want everything to be certified by the court, ऐसा होगा नहीं, right? So it cannot be issued against ministerial and purely executive acts. Basically purely that is in domain of ministries, certiorari नहीं लगवा पाएंगे आप. Now Sayyid Yaqub versus K.S. Radhakrishnan is the cardinal case law for certiorari and probation, in which grounds for certiorari and probation were elucidated. You will not mention the grounds, there is absolutely no need, but do try to mention this. ये आपका सैयद यकूब वर्सेस K.S. राधाकृष्णन का केस लॉ अगर मेंशन करते हैं तो भी ठीक है, नहीं भी मेंशन करते हैं, आई बिलीव इट्स कंप्लीटली फाइन. Mandamus is we command. It's commanding a public authority to perform a public duty belonging to its office. कि जी इनको बोलो ये काम करें. मान लेते हैं एमसीडी में कोई क्या बोलते हैं, झाड़ू वाड़ू नहीं लगाने आ रहा आपके यहाँ पे कॉन्स्टेंटली, इट्स रिट मैंडमस. कोर्ट जाए, इनको भाई इनको बोलो ये क्या बकवास है, राइट? आई एम पेइंग टैक्सेस फॉर दिस. अब ये एकेडमिक है, रियल लाइफ में ऐसा कुछ नहीं होता, यू नो इट. सो फॉर एग्जाम्पल लेट अस से ट्राइब्यूनल ओमिट्स a case which it was supposed to hear, then you go in for mandamus, right? Now it can be issued against a private individual but not for enforcement of private rights. So for example let us say ये आपका जो mandamus है, आप ये नहीं कर सकते कि वोडाफोन के ऊपर लगवा दीजिए और कह दीजिए नहीं रिचार्ज का पैक तो इतने का ही होगा, प्लीज कमांड देम. That's not absolute, that's, you cannot do that, right? So mostly public authorities against private individuals but not enforcement of private rights. Then which rights? Your fundamental rights. If that person is well violating them, then mandamus लगाइए और काम करिए. So basically only legal rights, anything that is statutory / constitutional in nature. Statutory नहीं slash नहीं, statutory and constitutional in nature. Prohibition is preventive, so it's purely a preventive writ. Certiorari is both preventive and curative. Alright, so it is superior jurisdiction से inferior court में जाते हैं. Restrained from exercising jurisdiction which it did not possess. The lower body did not possess that jurisdiction, so it has been restrained via prohibition, but it has to be done before the proceedings are complete. Certiorari after proceedings are complete. So post decision certiorari में आपको लगवाना पड़ेगा. So it's both preventive and curative. It cures the defect, it prevents the defect as well. Quo warranto is by what authority? So appointments to the public office made by executive authorities controlled and the legitimate right of person concerned can be protected. तो कृपया करके ये जरा पॉज कर लीजिए. I want you to write each and every line यहाँ पे describing quo warranto. कि बताओ जी किस खुशी में तुम इस गद्दी में बैठे हो, that's quo warranto. So it should be a public office and not a private one, because you cannot just go let us say to JP Morgan and tell them कि ये आपका CEO कैसे बना, मैं quo warranto की रेट लगाऊंगा. No, that you cannot do. But can you let us say file a quo warranto against UPSC chairman? भाई लॉ ऑप्शनल लिख रहे हैं, इतनी तो मतलब ज्ञान होना चाहिए आपको. लेकिन कभी यूपीएससी चेयरमैन के लगाएं सिलेक्शन सोल्यूशन रुकवा देगा आपकी. तो उसके अंदर वेल इफ द फंक्शंस आर ऑफ अ पब्लिक नेचर, ग्रेट, यू कैन basically apply. Any person can apply for it, whether fundamental right or legal right is infringed or not, but some public interest is involved. So any interested party, aggrieved party. So this is the writ जो कि interested party, aggrieved party both लगा सकते हैं. That is that even if you aren't directly affected by the appointment, but if you can you file it in public interest? Yes. Hopefully you watched the PIL in environmental law lecture already in the course. First ever reported case in which quo warranto was filed is re Cork Hill. That's reference to Cork Hill 1895. तो कृपया करके ये चीज़ आप लिख लेंगे. And I believe we have made a very solid answer. इससे पहले हमने अपने tortious liability relating to government. We have two absolutely stellar answers already ready on these topics. Now let us move on further in the course. इसके बाद मैं res judicata habeas corpus का lecture attach कर देता हूँ from YouTube. That should clarify the concept inside and out. And then we move on ahead with the other lectures in the course. Alright, take care, bye.